Judge.
How y'all doing?
Fine, yourself?
I'm doing great.
Good morning.
Thanks for making the accommodation with the switch. I really appreciate it.
Not a problem. Good morning, Judge Traver. Thanks for joining us this morning. I'm Amanda Carl. I'm the Vice Chair of the PCA JNC. You've been in front of us before, so you kind of know the drill. We'll all go around and introduce ourselves, tell you where we're from, and then we'll give you 2 minutes to do any opening remarks that you'd like to do. We'll ask questions, and then we will reserve some time at the end if you want to make any closing remarks. As you probably noticed, we have a video camera in this morning. Volusia Exposed is in here recording your interviews. Sit tall.
He has my wife is.
He has to sit tall. I can never sit tall.
He can't help
it.
So my wife is a physical therapist, and everybody asked me after I got married if I'd gotten taller, and realistically it was just my wife who has an orthopedic practice telling me to sit up straight. So hopefully that's good.
We all need that reminder.
Yeah.
Yes. Well, David, we'll start with you this time.
Good morning, I'm David DeArmas, and I'm with Kramer Price and DeArmas in Orlando.
Good morning, Vince Citro. I'm with the law offices of Horowitz and Citro.
Andy Bardos with Gray Robinson.
Fred Brenton with Shutz and Bowen, Orlando.
Good morning, Your Honor. Patricia Brownlee with the Brownlee Law Firm.
Craig Dyer with Public Defender's Office, Daytona.
Well, and good morning, everybody, and thank you for having me back. It's a pleasure to be here. I wanted to take my time, and I planned for 3 minutes, so I'm going to cut it a little bit short to just discuss a bit about my judicial philosophy. I think that's important for y'all to understand a little bit about what I believe so that you can take that into account during your deliberations. My philosophy has four core elements to it, and the first is a healthy respect for my role in our constitutional system. Second is a strong work ethic. Third is efficiency and promptness in running my docket and issuing my decisions. And fourth is a respect for and a commitment to professionalism and civility in everything that I do. I really want to focus on those first two, although I'm happy to answer questions about all four. I believe it's our solemn responsibility as judges to apply the law as it's written, as opposed to how we wish it were written. And I think in a vacuum, that's probably not an unconventional statement. I think that in practice, though, I can assure you that some of the hardest decisions I've made over the last 5 years involve applying the law when the result is something I don't personally care for. And the way that I keep myself grounded in my philosophy during those difficult times and during those difficult cases is to remind myself of what my role as a judge is. And it's not a legislative role, it's not an executive role. I think one of the reasons that we've thrived as a country is that when people do disagree, they have faith in our court systems that will give them a fair hearing, will give them a prompt hearing, and we will apply the law equally no matter who's in front of us and no matter who is sitting on the bench. And if I depart from that, I undermine who we are. More importantly, I cause chaos. I cause chaos for the lawyers who have prepared their clients by telling them that I'm going to apply the law as it is written. I cause chaos for businesses and the marketplaces in which they operate by changing the rules without telling anybody. And I cause chaos for people who can't afford lawyers, who trust us with problems relating to their property, to their liberty, and to their children. So I can assure all of you that I have the highest commitment to applying the law as it is written, especially in the most difficult cases. I think that a strong work ethic has to go hand in hand with that philosophy. I don't think that a lot of judges intentionally go out of their way to not follow the law. I do, however, think that certain circumstances, among them being very, very busy dockets, I think among them being very, very hard cases, can lead to intellectual laziness. I think that in those situations, you are far more likely to find an ambiguity in the law that really isn't there, or find a void in the law that doesn't really exist. And of course you resolve that ambiguity or fill that hole with what you hope the law would be. I hope my application reflects that I'm not scared to put in the nights and the weekends to look through our thousands of pages of statutes and our centuries of jurisprudence to find the right answer. And I hope that my background and qualifications give you all some confidence that I have the ability to find the right answer. So again, thank you for your time, and I'd welcome any questions that you have.
I had the pleasure of vetting you again, and normally I would have turned it down since I'd done so in the past, but I hadn't had an opportunity to do that since you became a judge, so I kind of wanted a second bite at the apple. So once again, no one would say anything bad about you, despite my best efforts. So I'm wondering if you can, normally what we would do if I vetted you, I'd go through anything that was glaring on your application. There was nothing. So I guess, can I just ask you, what was it like when you went to Tallahassee? How was it? Did you learn anything?
Yes, fascinating and reassuring in a lot of ways. It was one of the harder interviews that I've ever had in my life. I felt like the people that were conducting the process were exceptionally respectful of everybody involved. I felt like the questions that they asked were challenging. I felt like they really were trying to dig into our individual philosophy, how we would resolve cases, not leave us to talking points. It was humbling and fantastic to meet the governor. We actually interviewed in the governor's mansion, which, you know, I'm sitting in the lobby of the governor's mansion and I'm actually getting a little bit emotional because I'm thinking about all the people that sacrificed to put me in that chair. I don't believe that anybody gets to do the things that I've been blessed to do without substantial help. So I started thinking of those people and I had to tell myself to cut it out because it really wasn't the appropriate moment to have an emotional reaction. But yeah, it was a fantastic process and I can't thank you all enough for giving me that opportunity. It was really one of the great honors and has been one of the great honors of my career.
So you talked about your judicial philosophy and applying the rule of law, and I'm wondering if you can talk a little bit about the role of stare decisis when it comes to the rule of law, and what you think that interplay looks like and how important that would be.
Yeah, so that's, in my mind, that's probably the single hardest question that you could ask me. I think that most of my interview the last time around at the governor's office really addressed what the intersection of stare decisis and the textualist or originalist theory is. I think that ultimately a textualist or originalist theory has to be what carries the day. I think that there's no reason to keep affirming things that have an improper genesis. I thought that Justice Lawson, when he was on the 5th DCA, did an amazing job at looking at something like the circumstantial standard at JOA that we apply in criminal cases and saying, why are we doing this? By the same token, I think that if you didn't respect stare decisis in certain instances, textualism would just be a laboratory experiment. There are certain instances where, for example, society has developed a reliance on how stare decisis operates. You know, we see this a lot in criminal felony, where it would not be in the best interest of society to overturn it. I think that in the civil realm, where I used to practice, you know, you see it arising out of respect to property rights and respecting decisions in stare decisis that are anchored in individual property rights. I think ultimately, like I said, it's an incredibly challenging case-by-case scenario, but that hopefully gives you a little bit of framework as to how I would look at it.
Do you feel, I feel like you're the kind of guy that gets along with everybody, and I think that that's great. And I'm wondering if you go back to deliberate and you really believe that something should be overturned, but you've got 2 senior judges on the bench that are saying, it's clear PCA, what idiot wouldn't PCA it? Mm-hmm. How ready would you be if you thought that the precedent truly misapplied the law and we've just been doing it for years and years? I mean, do you think that you, I don't know how to put it, but do you think that you could be the kind of person that would say, nope, here comes my dissent?
I think I could, but I don't think that that's exactly how I would phrase it. I think that the 5th has a well-deserved reputation throughout the state for being an especially collegial body. I think that I think what you're asking me is, you know, could I try to change somebody's mind? And if I couldn't, would I have the courage of my convictions to write the dissent anyway? I don't think I would start by saying I'm writing a dissent. I think I would start by saying, let me see if I can change somebody's mind. And let me see if I can convince them that my way of thinking is the right way of doing that. I think when you go about it in that way, though, I think you have to come from a position of advanced preparation. I don't think that you can go to any senior judge. And frankly, if I get put on this court, every judge is going to be a senior judge. So I think that you have to come at it from a position of strong preparation to be able to say, I've looked at this. Here are some things that I'd really like you to consider that you might not have done. Secondly, I think that you got to understand that people internalize information and internalize that process differently. One of the things that I hope that I'm going to be good at is identifying how I can best approach people. If that's a matter of saying, hey, I've drafted a dissent, please take a look at it and let me know what you think. I don't necessarily know that's always going to be the best way, but if it is, that's what I'll do. I think that if it's just a matter of walking down to chambers and saying, hey, do you have a second to talk to me about this, patron? And I think everybody there would. At least that's my experience, having been up there as an associate judge a couple of times. And then if I still can't get somebody to agree with me, then I draft what I have to draft, and I stand by the courage of my convictions, and I write it.
Thank you.
Thank you.
Good morning, Your Honor.
Morning.
Do you believe that we should require the individuals that we select to move on to have judicial experience?
No.
Why?
I think that a strong judicial body is comprised of people from a lot of different backgrounds. I think that if the JNC that I'd interviewed with on the Ninth Circuit held that particular feeling, that I wouldn't be a judge. And I really respect them taking the chance on somebody who didn't have judicial experience, that based on everything else that y'all consider that I would do okay in what I do. And I think it would be hypocritical for me to say that you should only consider somebody with judicial experience. I think that factors for reasons that everybody understands, but I don't think it's dispositive.
What do you think is the biggest current challenge to the courts being able to maintain their integrity or independence?
I think the biggest issue that we're facing is the fact that our population has boomed in growth and there's not been a corresponding level of judges to handle the workload. And as all of you know, we lost our business court divisions in the Ninth Circuit this year. As a business litigator throughout most of my legal career, that's where I practiced a lot. It was fantastic to be able to go to our clients and say, even though we have fantastic federal courts, you know, you really want to be in front of Judge Blackwell or Judge Munyon, because they read everything, they're personable, they can get you in, you'll have hearing time, and they're going to follow the law. Losing that, to me, was necessary, because having served in a family court division, if somebody needs emergency child support, 3 months is not an emergency hearing for emergency child support. So I respect what Judge Lawton did. I think it had to be done. But I think that when you lose something like that, and you see how crowded our civil dockets are right now, I think that that's a real challenge and a real obstacle to litigants who have a pressing need to get one of their issues resolved, only to be heard that their first available trial date is in 2020. It's just not ideal.
And just one final question. What's the longest you've taken as a judge to issue your ruling on a motion?
So I'm really proud of this. I've never taken more than 3 weeks, and those are it's a sticking point for me, because I used to practice with Charlie Wells, who's a retired Supreme Court Justice, and something that he said to me really resonated, which is that I can deal with a good judge, I can deal with a bad judge, I can't deal with Judge Limbo. I can't wait and tell my clients what to do if a judge is taking 6, 10, 12, 18 months to issue a ruling. So in family court, I issued some 40-page decisions. And again, that's what I was referring to earlier. I'm not scared of doing those nights and weekends, because I understand how important it is for litigants to get their answers.
Thank you.
Does the separation of powers limit what courts can do? And if so, can you give an example or two of how the separation of powers might limit the relief that a court is capable of granting?
Yes, of course it does. I think that it could limit relief. For example, if litigants were urging a judge to direct the legislature how to fund, would be probably the biggest example that I could outline. There's obviously more.
Seems like your writing sample was one of those where the state failed to initiate the civil commitment proceedings for somebody who was in desperate need of that type of work. Judge, I don't have any questions for you. I will tell you, everybody I called for the people I had to vet, without exception, federal prosecutors, Supreme Court justice, 5 DCA judges, and your colleagues on the 9th, just sung your praises unconditionally. And so it was a pleasure to read your application, and a pleasure to talk to you today.
Thank you, Mr. Secretary.
Just a quick question about your views on the procurement firm's process, whether you think it's underused, overused? About
Well,
right? What do you think?
My views on that have evolved depending on what I was doing. You know, when I was a practitioner, I found the PCAs to be pretty frustrating in the sense that I wanted to be able to tell my client why we won, why we lost, or how we lost. As a trial court judge, I've come to appreciate them a little bit more, obviously, especially when it comes on the heels of a really challenging criminal case where all the issues were raised but none of the law is new. And I realized that the 50CA in so many ways is a court of last resort. And for so many decisions, it's the final word. I don't think that there is a lot of value in devoting what are understandably limited resources to further exploration of law that's very well settled. Personally, I think that I would take the position that whenever I can write and it's appropriate to write, I would write. Obviously, we write with reversals. You know, we write about why somebody hasn't won. I recently sat as an associate judge on a case where the parties had clearly expended a lot of time, a lot of energy. The briefs were incredibly well done. I was proud to have written on that particular issue precisely because of that reason. I know somebody was really disappointed, but at least there was no doubt as to why we ruled how we ruled. I hope that answers your question.
And I just have one question for you. We all know you're very likable. Everybody likes you. You're a very social person. How would you handle times when there can be lonely times on the 5th when you're kind of working individually, working alone? Would you be able to adapt to that kind of on your own island?
Yeah, absolutely. It's funny because when I first started talking to my wife about this was the first thing that she brought up. Are you going to be cool with all this reading and writing? I'm like, well, you know, my first job out of law school was clerking for a federal district court judge, and all I did was read and write. I loved that job. It's the second best job I've ever had. I think that if you wanted to be the sort of appellate jurist who just did that and didn't, you know, interact with anybody, if you were a pure 10 out of 10 introvert, you could do that and probably be fine. As you pointed out, I am not. I'm much more extroverted than that. But I think that there's opportunities for appellate jurists to do that, certainly through mentoring their law clerks, certainly for being involved, as I have been and would plan to continue to be, in voluntary bar associations and other groups. I love to teach. I've taught statewide judges on how to conduct domestic violence hearings. I've taught my colleagues at the 9th Judicial Circuit how to do competency proceedings in criminal cases. I love doing that, and I would continue to do that. So to the extent that I need to get my extroverted side a fix, I think I would be able to do that.
Thank you.
Thank you.
If being a federal clerk was your second best job, what's your first?
This one. My job is awesome.
So why do you want to change?
So the reason that I really want this particular job, again, kind of harkens back to my second favorite job, and that I really enjoyed doing those sorts of things. Also, I really do appreciate and thank the judge that I worked for doing some things that we weren't necessarily taught in law school. You know, how do you construe a statute? How do you write an opinion that is clear, cogent, tells the parties exactly what you did and how you did it in an understandable way that's respectful to everybody involved? That made a lifelong impression on me. And I feel like I have that opportunity to pay that back to 30 plus years of clerks that would work for me. So yeah, I mean, I'm blessed that I'm in a rare situation that very few people throughout the world have, which is that I'm applying for a job that I really want while having a job that I really love. So that would be my answer to that.
Okay, if you would like to, if you have any final words that you would like to say?
I'd just like to say thank you guys for your commitment. I know it's a real challenge to go through all of these applications, especially during this time of year, and reach out to everybody that we cited. So I want to thank you for what you've done. If you see it fit to nominate me for this position again, I will do my best to make you all proud.
Thank you so much,
Thank
Judge.
you.
Thank you, guys.
Thank you.
Happy New
Happy
Year.
holidays.
Happy New Year to you too.